Subcommittee will come to order. Today, the Subcommittee on Oversight and Investigations continues its investigation regarding the adequacy of the federal regulatory system that is supposed to assure that the financial reports of public corporations are fair, complete, and not misleading as a result of fraudulent activities or as a result of incompetence. Under the federal securities laws, the regulatory system involves responsible participation by corporate officers, directors, independent audit firms, self-regulatory organizations, the SEC, and the Congress. During the past 4 years, the subcommittee has held 22 hearings on this specific subject, as well as dozens of other hearings on closely related matters. These hearings have proven beyond doubt that there are serious and pervasive problems affecting the integrity of corporate financial reports. In the worst case, the low integrity of financial reporting has been a direct result of the low integrity of the senior officials running a company. There is a clear need for more effective enforcement to punish known offenders, to deter those who are tempted to violate federal disclosure regulations. However, the subcommittee has found its efforts on evaluating the activities of the organizations that are responsible for preventing and detecting fraud before it gets out of hand. The tremendous costs of frauds we have investigated amply demonstrate that in this case, an ounce of prevention is worth a pound of cure. Our investigation has developed in 3 phases. During the first phase, the federal agencies and the private sector organizations responsible for operating the disclosure regulatory system denied that fraudulent financial reporting was a problem big enough to justify changes in their procedures. The subcommittee challenged that assertion and pursued its inquiry into some rather spectacular frauds, where federal officials and independent audit firms faced massive litigation as a result of insufficient efforts by those agencies. The second phase evolved when the Treadway Commission, a private sector study group sponsored by 5 prestigious business and accounting groups, found in its preliminary report that fraudulent financial reporting was indeed a very serious problem that required substantial new initiatives by the regulatory system and by its participants at all levels. This finding prompted leadership by some participants to consider acting on recommended improvements, while other participants passed the buck and hoped that the problems would go away. Subcommittee is now entering the third phase, that of actually implementing necessary changes in the disclosure regulatory system. Most of these changes were recommended by the Treadway Commission as reasonable and as cost-justified approaches that balance the concerns of honest business people with the need to stop wrongdoers. Through its hearings, the subcommittee has identified some additional changes that must be made to complete an effective system of checks and balances that meets the public's legitimate expectations. The key to implementing necessary reforms is responsible leadership by the people and organizations with authority to require that proper standards and proper procedures will be followed by every company that wants to solicit money from public investors. The accounting profession, through the American Institute of Certified Public Accountants, has made substantial improvements in their audit standards to meet the Treadway Commission's recommendations. Their action, which is timely and decisive, as well as their willingness to work out the problems with the subcommittee and to achieve further improvements, is indeed commendable. Completing the cycle of change will depend upon the SEC and that agency exercising its leadership to assure that all corporate officers and directors operate within a system that recognizes the ever-present possibility of fraudulent or improper conduct by some people in the business community. Congress must also provide additional authority and direction in order to complete implementation of an integrated system that works effectively. Today, the subcommittee will hear from the SEC regarding its recent efforts to implement recommended reforms. The subcommittee looks forward to hearing that the SEC recognizes that it has a unique role and that agency has or will adopt a vigorous plan for implementing a complete package of reforms. Chair is happy to welcome our witnesses from the SEC this morning. Chair recognizes the gentleman from Oregon, Mr. White, for an opening statement.
Thank you very much, Mr. Chairman. I want to commend you, Mr. Chairman, for going forward with this very important inquiry. I was reminded at the end of last week that our subcommittee has held more hearings on the accounting profession than the Orioles have losses. And I think, in all seriousness, Mr. Chairman, this is going to be one of our most important, and I appreciate the chance to make a very brief opening statement. Mr. Chairman, like you, I believe the accounting profession and its advisory bodies have made significant progress in developing new procedures for the detection of financial irregularities. The Twedray Commission report includes many worthwhile proposals for protecting our citizens from financial fraud, and specifically calls on the Securities and Exchange Commission to implement several of these proposals by rule. Unfortunately, Mr. Chairman, it appears that the Securities and Exchange Commission plans to pass the buck to others as far as implementing key Treadway recommendations. Last night, I listened to a tape of the Securities and Exchange Commission's meeting last Wednesday, where the Commission gathered to discuss the agency's presentation here today. Mr. Chairman, that tape was a real eye-opener. Specifically, the Commission decided not to follow the Treadway Commission's recommendation that independent audit committees be established by SEC rule, and instead decided that the question of audit committees should be handled by the exchanges and the National Association of Securities Dealers. The Commission seems to think requiring audit committees is an unwarranted federal intrusion, though in my view they could be made up of just one or two local citizens, business owners, for example, who would be available to meet with the outside auditor if the need arose. Such a concept doesn't seem burdensome to me, Mr. Chairman, and I'm curious why it is to the Commission. Mr. Chairman, there's one other area I would hope that our committee would focus on. At present, there are still no mechanisms in place to provide for direct notification to regulators when an accountant learns that management has been involved in major fraud. In my view, this lack of direct notification is a glaring shortcoming in our financial system, and I think it's worth noting that several of the experts who've come before our subcommittee through these last 23 hearings have called for such direct notification. Specifically, the U.S. Attorney in Los Angeles, when he discussed the Z-Best case, said that direct notification would have been useful in that instance. And I would also like, with unanimous consent, Mr. Chairman, to place into the record a very excellent article by Dwayne Kohlberg, managing partner and the chief executive officer of Arthur Andersen, who also calls for direct notification. Again, it's my view that direct notification doesn't have to be burdensome. I don't think it would be too burdensome for the Securities and Exchange Commission to make some follow-up calls when, after direct notification, it's found that a resignation by an auditor is routine, and I'll look forward to asking some questions of the Commission on that matter as well.
Without objection, the document referred to will be inserted in the record at the appropriate place. The Chair announces that our first witness will be the Honorable David S. Reuter, Chairman, Securities Exchange Commission, accompanied by Mr. Daniel Gelzer, General Counsel, and by Mr. Edmund Colson, Chief Accountant. Gentlemen, you are all welcome. Gentlemen, it is the practice of this committee since it was first created that all witnesses appearing before the Oversight and Investigations Committee shall be sworn. Do any of you object to testifying under oath? Gentlemen, for your information, copies of the rules of the committee, rules of the subcommittee, and rules of the House of Representatives in the red and the brown book are down there at the witness table to inform you of your rights and the limitations on the power of the committee. Chair also observes, gentlemen, that you have the right to counsel if you desire. Do any of you wish to be advised by counsel during your appearance here this morning?
No. No, Mr. Chairman. No.
Gentlemen, if you will then please rise and raise your right hand. Gentlemen, do you solemnly swear the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Gentlemen, you may consider yourselves to be under oath. If you will please consider yourself recognized, the Chair will recognize you for such statement as you choose to give.
Chairman Dingell and members of the subcommittee, I am David S. Reuter, Chairman of the Securities and Exchange Commission. I thank you for the opportunity to testify today concerning the recommendations of the National Commission on Fraudulent Financial Reporting, the Treadway Commission. I will discuss the Commission's responses to certain of the recommendations of the Treadway Commission that directly affect the Commission. My written testimony discusses all of the Treadway Commission recommendations affecting the Commission and also includes an appendix discussing the remaining recommendations. I ask that my written testimony be included in the record.
Without objection, the entirety of your statement will appear in the record, and you may summarize in such fashion as you deem appropriate.
I would like to begin by emphasizing the importance of the Treadway Commission's work and my support for its objectives. Complete and accurate financial reporting by public companies is fundamental to the disclosure system underlying the stability and effective operation of our capital markets. Investors need reliable financial information when making investment decisions, and corporate officials require such information to perform their duties effectively. The Treadway Commission's final report identified as three of the most important elements in the detection and prevention of financial fraud as a company's internal control system, its audit committee, and its independent accountant. I'd like to speak to each of these. The most important ingredient in a company's financial reporting is management's commitment to complete and accurate financial reporting. Reduction of financial fraud must start with the managers of public companies, who in turn must put in place and monitor internal control systems. A crucial aspect in management's attention to internal control is their support of their own internal auditors. The effectiveness of internal auditors in performing their responsibilities, and thus the magnitude of their assistance in detecting and preventing financial fraud, depends on company management support in the form of adequate staffing and open communications between the internal auditors, management, and the audit committee. A second important mechanism for protection against financial fraud is, in the Treadway Commission's terms, an informed, vigilant, and effective audit committee. An audit committee can oversee the company's financial reporting process by reviewing the adequacy of the company's internal accounting controls and its compliance with these controls, by assessing the independence of an outside accountant, and by providing a focus for resisting pressures to report inflated revenues and earnings. Such an audit committee also helps to assure that independent auditors have the necessary support and access to information to perform their functions effectively. Independent audit committees are in a position to monitor the financial reporting systems established by management, to strengthen internal auditor independence, and to provide a critical buffer by insulating the external auditor from inordinate management pressure. While a company's financial statements are primarily the responsibility of its management, the independent public accountant plays a central role in the financial reporting system. It is the independent accountant who brings to the financial information the necessary technical expertise and objectivity. Users of financial information depend on the independent accountant's review of the company's financial statements. It is thus crucial that the independent accountant be alert to the possibility for fraud and misstatement, and that the accounting profession be vigilant in developing standards and mechanisms that facilitate the detection and prevention of fraud. And as discussed above, the detection and prevention of financial fraud depends primarily on those involved in overseeing and participating in the financial reporting process, the company's internal control system, its audit committee, and its independent accountant. Nevertheless, other entities, such as the Commission, also play an important role in this process. The Commission acknowledges its direct role in overseeing the corporate disclosure process and its indirect role in overseeing the accounting profession. The Treadway Commission's final report makes an important contribution to the efforts of the Commission. The Commission has already taken a number of actions that address the matters considered in the Treadway Commission recommendations. In April of this year, the Commission adopted rules regarding disclosure by companies of changes in independent accountants and potential opinion shopping situations. These revisions provide that a company must disclose information concerning consultations with its newly engaged accountant that occurred during the 2 fiscal years and any subsequent interim period preceding the accountant's engagement if, 1, those consultations were or should have been the subject to Statement on Auditing Standards number 50, that is, if they involve the accountant in providing specific advice on the accounting treatment applicable to a specific completed or proposed transaction, or 2, those consultations concern the subject matter of a disagreement or reportable event with the former accountant. In such situations, the company must disclose the issues discussed, provide a brief description of the new accountant's views on these issues, and include a statement by the company indicating whether it consulted the former accountant on those issues, and if so, a summary of the former accountant's views. The new accountant has an opportunity to review the company's summary of its views and to provide additional information to clarify those views. The company is also required to request the former accountant to review the disclosure and to provide a statement as to whether the former accountant agrees with the company's summary. Both accountant letters are required to be filed as exhibits. We think this system works well. In adopting these changes, the Commission has proposed for comment amendments that would reduce from 15 to 5 calendar days the time period for a company's filing of a Form 8K disclosing a change in independent accountants or the resignation of a director, and reduce the time period in which companies are required to file letters provided by their former accountants. In proposing these changes, the Commission has indicated that accelerated disclosure of concerns by the former accountant would aid in the protection of investors. The Commission has also addressed another area considered by the Treadway Commission by proposing for comment a requirement that accountants certifying financial statements filed with the Commission be subject to an objective review by other independent accountants. Under this proposal, an accountant would be required either to undergo a peer review under the auspices of an acceptable peer review organization or to have its review supervised directly by the Commission. The Commission staff is currently reviewing the comment letters received on this proposal and is preparing a recommendation with respect to the proposal, which should be considered by the Commission in the near future. With regard to enforcement remedies contained in the Treadway Commission report, the Commission supports the recommendation that the Commission be provided with the authority to impose civil money penalties in administrative proceedings, and that courts be authorized to impose such penalties in Commission injunctive actions. In addition, although the Commission has successfully obtained court orders in some cases barring or suspending an individual from serving as an officer or director of a public company, the Commission supports legislation specifically authorizing courts to provide such relief, as well as a congressional grant of authority to bar or suspend corporate officers and directors in administrative proceedings. While the Commission believes that its authority under Exchange Act Section 15C4 makes the recommended cease and desist authority unnecessary, it would support expanding its current authority by adding Exchange Act Section 16A to the provisions for which a proceeding under Section 15C4 is authorized. I have directed the Commission staff to develop legislative proposals regarding all of these areas. In addition to pursuing these legislative efforts, the Commission will propose for comment a rule that would require annual reports to include a report by management on internal controls, similar to the report recommended by the Treadway Commission. Shareholders may benefit from this report, particularly because new and existing auditing standards require extensive auditor's review of the management report. These standards require a company's independent accountant to have knowledge of the company's internal controls and to read all information in the company's annual report, including the management report on internal controls, and to take appropriate action if the information is materially inconsistent with information appearing in the financial statements or contains a material misstatement of fact. Recognizing the importance for public companies of an independent audit committee, the Treadway Commission has recommended that all public companies be required by Commission rule to have such a committee. Although most companies with actively traded securities already have an audit committee with at least a majority of independent directors, the Commission believes that it would be appropriate for the securities self-regulatory organizations to re-examine and upgrade their audit committee requirements. Accordingly, the Commission intends to communicate with the NASD and the exchanges to encourage them to consider upgrading and expanding their audit committee standards. The recommendations of the Treadway Commission demonstrate an important commitment to improving financial reporting by public companies. These recommendations challenge all of us with responsibility for financial reporting to take appropriate steps to produce these improvements. I know this statement has been somewhat long, but it will be the only statement presented by the three Commission witnesses this morning. Thank you.
Thank you, Mr. Chairman. Chair recognizes the distinguished gentleman from Oregon for questions.
Thank you, Mr. Chairman. Mr. Reuter, as you heard me say, I listened to the tape of the Commission's meeting last Wednesday prior to its appearance, and I was really amazed to hear that the Commission plans to pass the buck on the key Treadway Commission recommendation that independent audit committees be established by rule by the Securities and Exchange Commission. And I would like to go through some of the history on this, because that's one of the key recommendations of the Commission report. And clearly the Commission's decision on Wednesday to have this taken up by NASD and the exchanges is just passing the buck on to others. Now, the first thing I'd like to do is address specifically the Commission does have the authority, does it not, to require by rule that all public companies have independent audit committees?
Yeah, is that a question?
Yeah. Doesn't
yes,
the Commission have
we believe that we do have that power, sir.
The Commission also commends the SEC for not wishing to impose any unnecessary direct government regulation, but experience with independent audit committee requirements demonstrates that it is now time for direct action by the SEC. Do you agree with that Commission statement?
Yes, sir, I do.
Mr. Reuter, the SEC testified before the Senate Governmental Affairs Committee on June 13, 1977, more than 10 years ago. That time, the chairman said, and I quote, "I think the development of the concept of an audit committee may be the most important development in the whole field of corporate governance in some time. If it works effectively, it is important not only in helping to assure the independence of the auditor, but in some ways may even result in a reassumption by boards of directors of more of their responsibilities, which would be beneficial for the system as a whole." And Mr. Williams goes on to say, "In the Commission's judgment, one of the most important approaches to the strengthening of auditor independence lies in the formation of audit committees composed of outside, independent corporate directors." He also stresses that without that, there is not the sense of independence on the part of corporate boards that is really necessary. My question would be, given this long track record of the Securities and Exchange Commission calling for independent audit committees, why hasn't the SEC acted during the past decade to make this audit committee requirement for all publicly traded companies?
I think in answering that question, I may have to give you a more extended answer than I might otherwise be the case, but I think one has to recognize that the phrase "all publicly traded companies" encompasses companies traded in many, many markets. We have the major market, the New York Stock Exchange. We have the American Stock Exchange. We have within the National Association of Securities Dealers automated quotation systems, two levels of company. One are national market system securities and at certain standards, and others are not. And then finally we have a group of public companies which are traded in what's called the pink sheets and do not appear in the automated quotation system. These gradations of companies really are size questions, and there are, I think, some distinctions to be made with regard to the way one looks at all of these size questions. Over the past years, the Commission has, as you know, been urging both formally in one case through a letter and informally in others, the exchanges and the NASD to impose audit committee requirements. The New York Stock Exchange requires an audit committee to be composed entirely by independent directors. the NASDAQ NMS securities companies are required to have an audit committee composed, a majority of which are composed of independent directors, and the American Stock Exchange has an audit committee recommendation that the audit committee be composed entirely by independent directors. With regard to the smaller companies, the Commission has been aware over the years that there are some companies for whom the requirement of having an independent audit committee may be burdensome. And even within the Treadway committee report, there was a recognition that there may be burden in establishing audit committees which are composed of independent directors. The reason that the Commission has proposed to move, so my first answer is that we have done a great deal towards towards promoting independent audit committees, and my second is that in proposing to move to the exchange and NASD method of implementing the audit committee requirement and proposals, we are looking towards a more evolutionary change, and we want to have them communicate directly with their member corporations. And that really is the, I know, an extended answer, but where we come from.
Mr. Reuter, though, any way you look at it, you aren't doing what the Treadway Commission called for in its recommendation. They said that there should be direct action by the SEC by rule to require independent audit committees.
That is correct.
And you aren't doing that.
That is correct.
And I guess what I'd say, your argument about the burden, it seems to me, first of all, when the public is in danger, as they were in the ZBES case and a number of other kinds of cases, it doesn't seem to us or the Treadway Commission to be all that burdensome to require that there be one or two people who would constitute an independent audit committee who'd be available as needed.
I don't think there's any. I don't think there's any disagreement at all between the Commission and the position that you've just stated. We're simply talking about the means of accomplishing that goal.
You are altering the Treadway Commission requirement. You've said that in response to me. Treadway says that there should be independent audit committees by rule, by direct action by the SEC, and you're saying, and I'm going to get into this, that in a sense we'll encourage people to do it voluntarily. Commissioner Grunfest calls for incentives to get this done. And it just seems to me that in not carrying out the Treadway Commission recommendation on this key point, the public is going to be less than adequately protected. And I'm happy to yield to the Chair.
Mr. Chairman, the letter that the SEC sent was sent by Chairman Hills, was it not?
I do not know, sir. It was.
Now, when did Chairman Hills leave the Commission?
Pardon me?
When did Chairman Hills leave the Commission? It was back about 1979, was it not?
Something like that, yes.
So Chairman Hills sent a letter on this, and you're saying that the Commission has shown great interest in carrying these things forward, but the last action taken by the Commission that you can identify was a letter by Chairman Hills in 1979. That is 9 years ago. Nothing has happened since.
The last letter, I do believe that's true, sir, but
So it's 9 years ago you sent a letter, and you're here to tell us about the vigor with which the committee is addressing this problem? Or rather, the Commission is addressing this problem?
Well, we were aware, of course, that following the New York Stock Exchange's imposition of this requirement.
The New York Stock Exchange has done something. Nobody else has really done anything.
Yes, sir. As I reported earlier, the NASD requires that all NMS companies in their system must have a majority of independent directors, and the American Stock Exchange.
That is a majority, but not complete.
That's right.
So that the Audit Commission in that instance could be well larded with people who are on the inside, who were participants in the rascality that the audit is supposed to find.
There is a great deal of disagreement as to whether or not there should be any non-independent directors on an audit committee. My personal belief is that that there should not. But that we are moving and intend to move to this.
What has the Commission done with regard to the Treadway report since the Treadway report was filed?
As I indicated, we have adopted a rule on auditors' resignations. We have proposed a rule on
With regard to this
Pardon me?
specific point, Mr. Chairman.
I'm sorry?
With regard to this, to the specific point with regard to the specific point to which we are addressing ourselves.
We discussed this matter in a meeting in preparation for this testimony to determine what action we
these matters not infrequently.
Pardon me?
And I say commissions not infrequently address these matters by discussion, but that does not indicate that the Commission has done anything other than discuss it. What has the Commission brought forth since the Treadway Commission has recommended that this action be taken?
With regard to Audit Committee, sir?
Yes, sir.
We have taken no action other than to indicate that we intend to communicate with the NASD and the exchanges to encourage them to consider upgrading and expanding the scope of their standards with respect to audit committees. If they don't do that, the word encourage is a strong word in my view, and if they don't do that, they will then hear from us again.
The last action that the Commission has taken on this matter was a letter from Chairman Hills in 1979, 9 years ago. Subsequent to the filing of the report by the Commission, or rather by the Treadway Commission, the SEC has discussed the matter. The SEC has done nothing other than to discuss the matter.
The Commission has Rule 19C powers to change rules of the stock exchanges, and it has acquiesced in the listing standards of the NASD and the Amex as well to provide audit committee protection for companies in those areas. So to really say that we have done nothing is not quite accurate.
What would be accurate, Mr. Chairman? You haven't done anything. Chairman Hill sent a letter. The Commission has discussed the matter. The Commission's discussion was basically that actions of this kind constituted intrusion into corporate governance. And the end result is that although you have powers down there, you have exercised none of them to see to it that this recommendation is in fact implemented.
Sir, the discussion I believe you're referring to is a discussion which occurred at our open commission meeting last week. There was quite strong disagreement, I may say, between commissioners as to whether this action was a corporate governance matter or not. My personal statement was to the effect that it did not constitute undue interference with corporate governance. Other commissioners took an opposite view.
Well, you have told me nothing, and I apologize to the gentleman from Oregon. You have told me that nothing that is being done to secure positive change. You told me that the New York Stock Exchange has rules. You have told me that the Amex has rules. You have told me nothing that you have done to see to it that the others do the things that need be done to bring forward effective accomplishment of the recommendations of the Treadway Commission.
On the Audit Committee matter, we have done nothing more than to say we are going to urge that the NASD and the exchanges, other than the New York Stock Exchange, which already has the rule requiring independent audit committees, we're going to encourage these exchanges and the NASD, which I may say covers almost all, I think does cover all publicly traded companies.
What, 500 companies? That's 500 companies on the New York Exchange?
The NMS...
no, the New York Exchange has
New York
got
Stock Exchange, I think, has something like 1,700 companies.
1,700.
And Amex has about 900 companies. And how many OTC companies are there?
Amex does not have a rule as such, does it? Amex only recommends to its
that's
companies.
correct.
What does that recommendation mean? It means they can do it or not do it, right?
That is right.
Okay, so it means, so for all intents and purposes, that's kind of like the prayer at the opening of the session. It doesn't have much significance. It doesn't accomplish a great deal. Chair, apologize to the gentleman.
Mr. Chairman, frankly, I think you've been charitable in your characterization, because the fact of the matter is the SEC is backing away from the Treadway requirements. For example, the Treadway rule with respect to exceptions to the independent audit requirements says, and I quote here, "Exceptions should be granted only in the most unusual cases and should be reconsidered at appropriate intervals rather than granted on a permanent basis." So, Mr. Reuter, the Treadway Commission is trying to be sensitive, as all of us are, to the question of small, publicly held companies. There's a possibility for an exception. Why not go with the Treadway proposal, which is to require across the board by SEC action independent audit committees, and use this exception arrangement that Treadway has called for to deal with special cases? What's wrong with that?
There is nothing essentially wrong with what you're suggesting. It is simply a matter of the means of getting to the result that one is seeking. One can get to that same result utilizing the SROs instead of doing it directly. The SROs, and particularly the NASD, I may say, has direct contact with the firms that are trading in the system. I participated in my period before coming to the Commission in a session which made it clear to me that the NASD has direct corporate contact and will be able to discover what the problems are that exist with establishing independent audit committees. And one needs to find out in an orderly way what the objections may be from the community that it's being asked to impose the audit committee. The Securities and Exchange Commission has an obligation under its statutes to consider costs and benefits of each of its rules. And one of the ways to find out what the costs will be to small companies for having audit committees is to allow the system of SRO contact to take place.
Mr. Reuter, in what circumstances should the Treadway Commission's rule, their rule for independent audit committees, not be implemented?
Under circumstances, I believe, their suggestion that audit committees be composed entirely of independent directors?
Correct.
My view is that the circumstance in which one ought to avoid imposing that requirement is when you have a company of such small size or unique characteristics that the protections given to the public outweigh do not outweigh the costs to that company. We do have to protect small business, and there are impediments which can be placed in the way of effective operation of small businesses, and that is really the question that we're dealing with: how to put those requirements in place for small businesses in a way which aren't injurious.
We wish to be very sensitive to small business as well. I think the Treadway Commission report clearly lays out a vehicle for doing that. They say an exception could be granted. What I'm concerned about is that you want to just, across the board, waive the Treadway rule, and that would let companies like ZBest and others perhaps not ever have independent audit committees. I think that's a mistake, and I think you go way too far to back away from the Treadway requirement across the board.
Well, I think it is not to be understood that there is a commission. I'm choosing my words carefully. It is not to be understood that there is a commission position backing away from the independent audit committee proposition. What we are talking about is a system of reaching a result which will be favorable.
You have backed completely away from their proposal that independent audit committees be required by rule, by SEC direct action, and then have an exception in unusual cases. You have decided not to comply with it. I heard the tape. Even Mr. Gelser says that your idea of re-examining things and suggesting voluntary matters, and I quote here, Mr. Gelser said the SEC's suggestion for re-examination by the SROs and others is not a very radical proposal, and I quote here, or in any way different from what we have today. That's really what's going on, Mr. Reuter. You all have decided to stay with the status quo. The Treadway Commission calls for something very different, and I think that's a mistake.
I will tell you that I am under oath, and that is a mischaracterization of my position. I cannot say what is in the minds of each of the other commissioners.
No. I'm quoting from the tape. Your own testimony here today said that you were not going to support what the Treadway Commission has required across the board.
No, sir. That is not an accurate statement of what my testimony has been. I have said we are going to encourage the self-regulatory organizations to upgrade their standards, and by so doing that, we will be monitoring their results, and we will be asking whether they are dealing with the need to upgrade and expand the scope of the standard.
I want to yield the Chairman only, Mr. Chairman, if I might. Voluntary encouragement hasn't done it so far, Mr. Reuter. The Treadway Commission calls for something different. That's, I think, what our dispute is about, and I'm happy to yield to the Chairman.
Treadway Commission says this: to implement the Commission's recommendations that all public companies have independent audit committees, an SEC rule is necessary. The SEC has long recognized the importance of independent audit commissions to integrity of financial reporting, but the SEC has deferred to the policies and practices of the New York Stock Exchange and other self-regulatory organizations. Now, you tell us that you are going to encourage the self-regulatory organizations to take certain steps. You tell me that, you tell the gentleman from Oregon that that is the Commission's policy. That is at wide variance with what the Treadway Commission has recommended. You tell us that the last official act of the committee was to write, of the Commission, was to write a letter to the New York Exchange in 1979. You tell us the matter has been discussed. You tell us that you are going to encourage the independent regulatory agencies to carry forward certain actions, i.e. independent audit committees. You have not told us anything that concrete that has been done other than to move towards encouraging the SROs to do these things. That is at wide variance, first of all, with the recommendations of the Treadway Commission. And it is also at wide variance with what I think the needs of the case might be. In the case of the Z-Best matter alone, one sharpshooter cost investors, banks, and others $70 million because he did not have an effective, meaningful audit committee which was functioning as it properly should to see to it that the books and the records and the reports and the filings and the statements of that company, in point of fact, represented reality and what was going on. Now, Mr. Chairman, you're down there. You're supposed to do a good job of regulating. This committee will support you when you do. I want you to understand that you will not escape criticism when you do not. You have the misfortune of following on others who sat idly by for 7 or 8 years while the letter which had been sent to the New York Exchange was the only action which had been taken. You now find yourself in the awkward position of having had 6 months or a year of time of your own in that particular position, and nothing has been done. You cannot tell us that you have done anything to implement these recommendations. You have told us you're taking your own course. Your own course appears to be a continuation of a course which I find to be very unsatisfactory in this matter, as pointed up by the comments of the gentleman from Oregon. Now, what do you have to say?
Sir, I have, in the course of my career as a corporate lawyer, participated in 2 projects which have dealt in great detail with this problem. I was a participant in the drafting of what's called the Corporate Directors Guidebook, and I have been a participant in the American Law Institute's Corporate Governance Project. Both of these, both the Corporate Directors Guidebook, which was a product of the American Bar Association section of Corporation Banking and Business Law, and the American Law Institute Corporate Governance Project, have dealt with this question of audit committees. And this is particularly the American Law Institute is a reform-minded, very substantial group of corporate lawyers who are very much interested in getting the right results. They too have expressed reservations with regard to the issue that I discussed earlier with Congressman Wyden, and that is the question of how to protect or deal with the small public company. Now, I do agree with you that the Commission has not taken strong action in this area, and I don't mean to dispute that. I merely mean to say to you that there are reasons why, at this particular juncture, the Commission is not agreeing with the Treadway suggestion that this be imposed by Commission rule.
Mr. Chairman, all you've got to do to find out what the problems are is put forward a notice of rulemaking. Let people come in, submit comments to the Commission about what it is they find wrong with the Commission's recommendation. You can write a rule using the traditional rulemaking mechanisms that you have down there at the Commission without any problems at all. And I think for you to permit a situation to continue here in the same fashion that it is not something that is easily defended before this committee. Chair, thanks, gentlemen, for yielding.
Thank you, Mr. Chairman. I just had one other line. Let me use this as an example, because I think the point you're making, that the small companies and how to deal with them is a concern of all, and that's why I cited the Treadway language to talk about exceptions. What would be wrong with adopting what Treadway calls for, which is to do this by rule, by direct action, have the exception that Treadway calls for, and spell out that small companies could have an independent audit committee of just 1 or 2 persons there locally who would be available to meet on a regular basis with the outside auditor if needed. What would be wrong with implementing the Treadway recommendation along those lines, Mr. Ritter?
I think it could be done by rule.
Well, I'm pleased by that, and I would like to see us do what I have just called for by rule. When the meeting is over, we will work with your able staff who's come to visit with me on a number of occasions, and let's get this done by rule as the Treadway Commission calls for. Let's come up with something realistic to deal with the small business, and I appreciate your answer, and I have a feeling we'll be able to make some progress in this hearing if we can pursue our business in that fashion.
In the meantime, we will encourage the SROs to take steps in the hope that they will accomplish that before we can finish our rulemaking proceeding.
Voluntary encouragement is the staff of life, and I'm pleased that you'll pursue this by rule, and I appreciate...
I cannot commit the Commission to proceeding by rule. I can only tell you that I believe it's possible to proceed by rule.
And the idea that I have suggested to deal with the small committee, the small publicly held companies, is a reasonable one.
I don't mean to accept the detailed way in which you describe how to deal with the small companies, but I do think it would be possible to find a rulemaking device to deal with the problem of the small company.
Mr. Chairman, I'll have some other questions after that.
Chair, thanks, gentlemen. Chair recognizes the gentleman from Tennessee, Mr. Cooper.
I thank the Chair. Mr. Reeder, it does surprise me that after this committee has held some 22 hearings on the subject that you would come up before us with less than a wholehearted endorsement of the Treadway Commission findings. And on this subject of independent audit committees, each of the members before you is a veteran of the Small Business Committee. We're each deeply concerned about the problems of small business, including small publicly held companies. But I would like to ask you some specifics, because it seems to me that you made a judgment that must have been based on some sort of balancing test, that the burden placed on small publicly held companies would be so great as to outweigh the benefits that would accrue if you did have an independent audit committee on each board. I'd like to explore specifically what that burden would be for small publicly held companies. Is there any reason that, as my colleague from Oregon pointed out, that you can't have an audit committee composed of 1, 2, 3, or 4 people? I guess it couldn't be a one-person committee. Can it be a one-person committee?
Not, to my understanding, most of the modern corporation acts require two
One or
people.
two.
Most of the modern corporation acts require 2 members of a committee.
Okay, so
I don't know if that's all or what the numbers are, but the states differ in that regard.
well, let's assume we're talking a minimum of 2 individuals. What is the average fee nowadays for serving on the board of a publicly held corporation? What is the compensation? $5,000, $10,000?
How large the company is. The fees for the largest public companies, I understand, are quite substantial, but for the small companies, very modest.
To be an independent director, all it means is you don't have any role to play in the management of the firm, right? You're not an officer of the company. You're an outsider.
It depends how you define the concept of independence. The Treadway Commission report, I think, substantially follows the New York Stock Exchange model that says you must be in a position where you could I'm paraphrasing, where you could exercise independent judgment uninfluenced by conflicts.
So it wouldn't even preclude individuals that held a small ownership stake in the stock of the company as long as they were judged to be capable of exercising independent judgment?
Yes. One of the problems in a small community, as I'm sure you are aware, is finding someone who's in the community who doesn't have the kind of possible conflicts that we may be looking at. It is difficult to. It depends whether the local banker, for instance, is someone that you think would be adequately independent. I don't mean to say it's impossible. It's simply something that has to be looked at carefully.
Well, I'm from a small community of 12,000 people. We have 4 banks in that town, and I can assure you there's no shortage of people volunteering to be on the boards of any of those banks. Most of them are completely independent, too. They have no ownership stake, no vested interest. They might sell groceries to some of the people, or they might, provide other services of that type, but they don't have a significant financial stake. But my real question is this. Assuming we're talking 2 individuals who are independent of the board, and assuming a small publicly held company pays a minimal fee to a member of the board, is that any great burden to have 2 independent outsiders serve on the audit committee? The burden to me seems to be minimal.
The problem is not necessarily financial cost. It's a question of being able to find people to exercise those responsibilities.
Are there many small publicly held companies located in communities smaller than 12,000 people, such as my hometown? You must be talking minute communities.
Publicly held can be defined in many ways. If the stock is traded in the pink sheets, it can be a very, very modest company and still be publicly held.
But I think the hypothetical that you're pointing out of communities so small as to be unable to produce 1 or 2 outside individuals who are independent and who could serve on the board in a meaningful capacity is a completely unrealistic hypothetical that you're tossing out.
Qualified, independent, and willing to accept the responsibilities of audit committee membership.
Mm-hmm. Well, even so, I would suggest that you follow the advice of my colleagues that you can have a rule with exceptions to it in the case of extreme geographical remoteness or extreme limitation on the number of qualified personnel in the area. But I would doubt that if a rule were in place that you would find very many companies who would be able to qualify under such an exception, because even the least populated areas of our country have a substantial number of able, qualified people who live therein.
I agree with you, sir. I came from a small community myself, and I know that there are many of those people there. I just think it's important for us to find out what the reactions will be from this very community before engaging in the rulemaking process, whether it's through the commission rule or through an SRO listing standard. I would certainly want to get input from that community. It may be that the problem is not as serious as some believe, and I would very much like to have that answer.
But just from this brief exploration, it seems to me that the proposed corporate burden is minimal at best, whereas the benefit of having an independent outside committee could be extraordinary. And it seems to me that that weighing process that you've apparently been engaged in, at least implicitly, has reached a remarkable result.
I cannot tell you that we have engaged in the kind of close, factual inquiry that we would were we to be in a rulemaking proceeding. But I can tell you that the inquiry will be done, I think, by the SROs when they ask themselves whether to have such a rule and what the exceptions might be. And should we engage in rulemaking eventually, then we would be making the same inquiries.
Would the gentleman yield?
I would be happy to yield.
Mr. Chairman, when the rulemaking is initiated, the traditional way in which it is done is that the Commission announces a rulemaking, and they put out a notice of proposed rulemaking. That notice embodies, as usual, in the usual form, although it can be different, that a rule of this general character is under consideration. That serves as notice. It also contains a request for comments. Now, I detect in your comments you're saying you want to get the comments before you commence this rulemaking.
Well, it's not always that we proceed exactly in the way that you have discussed, but I
That's
certainly
the
think
standard way.
Yes, it's quite possible, however, to have a public meeting before entering into rulemaking proceedings, and that's simply another way to go about matters.
But
I would imagine that if the Commission were to seek to adopt a rule, it would either issue a concept release, which is one way to proceed with it, or to engage in a rulemaking procedure with a comment period.
In any event, you have full opportunity to get the views of everybody who's involved,
yes,
find out what's going on out there, and to craft after you consider it, or not craft if you find that it's inappropriate.
That's correct.
And a fully appropriate rule with full opportunity for everybody to be heard and give you the necessary comments. And the only trouble I have with what you're telling me, Mr. Chairman, is that this matter's been laying around the Commission for now 9 years at least. Nothing's been done. You've got to have the Treadway Commission come forward, tell you something ought to be done. This is a responsible institution. It's composed of people in the accounting business who've studied this whole matter with a great deal of care. But the Commission is going to foist it off on the SROs. Now, what's the Commission doing to make the SROs do something about this matter? Is the Commission doing anything?
Well, we've only met, we only reached this conclusion last week, so I gather that what the Commission has not done anything yet, but the word
Well, the Commission's had the Treadway Commission report for how long?
Since October of 1987.
Okay, so that now is 6 months old.
I know that for sure.
So you've been sitting on this for 6 months. I'm delighted that the pendency of this hearing apparently encouraged the Commission to move with greater vigor on these matters.
Well,
I would be more comfortable still if I felt that the Commission's vigor were taking into channels which I viewed could be effective. The last official action by the Commission was a letter sent by Chairman Hills to the SROs in 1979. It doesn't seem like the Commission is moving with any enormous vigor or with any enormous speed.
Well, I don't mean to sound defensive, but we have been waiting for the opportunity to appear before you and find your views. They are instructive and influential with us. We had all, at the same time, as you know, lost our chief accountant, and through a very careful process appointed Ed Colson as chief accountant early January, wasn't it, Ed? Early January, and I felt it important to give him some time to move into the management of the accounting area, and I'm pleased that he is proceeding in a very vigorous way. And I think one of the things that has to be recognized is that although you're paying a great deal of attention to the audit committee here, there have been great strides taken by the profession, the same ones you indicated earlier, and Ed Colson has been participating actively with them, and indeed has taken some steps independently to encourage more action at the accountant level.
Well, how long has Mr. Colson been with the commission?
How long has Mr. Colson been with the commission?
Since 1975, sir.
And what was your position since 1975, Mr. Colson?
Since 1975?
Yes, sir. You've been in the in the accounting end of the commission since 1975.
That's correct, sir. I started there as
I guess, am I to understand that during that time you've been totally unfamiliar with this problem that we now address of independent audit committees inside the companies subject to regulation by the SEC?
No, sir. I might point out that I started out at the very lowest level of the...
You were even there when the letter was written by Chairman Hills.
It's probably true. Yes, sir.
Rip Van Winkle slept 20 years. I hope the commission will sleep rather less on this matter, and I apologize to the gentleman from Tennessee for taking so much of his time.
Rum, I appreciate the chairman's line of questioning. Mr. Reuter, I'm a little unclear to follow up on the chairman's line of questioning. Do you anticipate in the near future writing a letter to the SROs in any way informing them or encouraging them to adopt guidelines concerning independent audit committees?
Yes, I do.
So in the near future, we can expect a letter from the SEC to go to all the SROs?
Yes, by letter and by telephone. There's a great deal being done informally as well.
And that letter would encourage them on their own to require independent audit committees in most cases?
Well, the Commission's present position is that we would encourage them to consider upgrading and expanding the scope of their standards. Whether the letter will, I just can't tell you exactly what that letter will contain at this point.
I see. The other points listed in your testimony, the various recommendations, struck me as being similarly weak or half-hearted in terms of wanting to implement the Treadway Commission recommendations. The one exception being, I did think you were very strong on the indemnification question, and I would like to congratulate you on that. That at least
we didn't accept the Treadway Commission. I know. If you understand that.
I appreciate your variance with the Treadway Commission there. I'm very proud of you on that one.
Well, I would say I don't really think that, except for the Audit Committee matter, that we have departed very far from Treadway.
Well, maybe I'm seeing bigger differences than in fact exist, but I personally was disappointed when you did not think that requiring an Audit Committee letter describing their activities during the year, when you concluded, I believe, that that would not yield significant additional information. I thought that you were being a little bit soft, because to me it's very important, if you're going to have an Audit Committee, that they report on their activities during the year. In my opinion, it tends to encourage them toward greater activity and greater thoroughness if they have to disclose how many times a year they met. The other things that worried me a little bit, you were requiring only a concept release, I believe, regarding whether independent CPAs should review quarterly financial data. You want us to wait on any civil penalty legislation, and you don't want any type of cease and desist order, it seems. Well, those things taken together, it made me think that you weren't really greeting the Treadway conclusions with much enthusiasm.
Well, the concept release on cost questions is quite part of our usual proceedings, in which we do want to find out what the cost questions are. Auditor participation in quarterly financials is an expensive proposition, and we really want to know what that will cost. With regard to the the question of what should be in the, whether the Audit Committee should send another letter, that is simply a judgment call on our part that the recommendation doesn't do very much. With regard to the cease and desist power, we believe that our 15C4 powers are essentially equivalent of cease and desist orders, and we have asked that the 16A powers that 16A be added to that section to give us the equivalent of cease and desist. I think you also should know that our action in supporting explicit statutory authority to bar or suspend corporate officers is a very dramatic and very positive step, which we think is an important one, and that in addition that our decision that we would seek civil penalties is also an important one. And notably, if one did listen to the tapes on at the Commission meeting, one would find that we were dealing not only in those areas, not only with fraudulent financial reporting, but with a whole range of Commission activities, of securities law violations, so that we really have, I think, stepped quite vigorously and firmly forward with regard to certain of those activities. I suspect that when the corporate bar, the corporate community, learns that we really will be seeking power to bar corporate officers and directors from persons from becoming continuing as officers or directors of a public company, they will regard us as being vigorous and not soft.
Well, perhaps the explanation didn't adequately convey your feelings, but when I read that section of it, it seemed to me that you already had considerable authority under past court cases to effectively disbar certain officers from corporations, certainly in the case of repeated violations. And in that case, you did commendably choose to seek explicit statutory authority to make sure that you had that power. But in other cases where there was a possibility that you could go halfway or partway toward a goal, you chose to request no authority. We
did, as I understand it, we supported a congressional grant of authority to bar or suspend corporate officers and directors in administrative proceedings. That would be in our 15C4 administrative proceedings if the legislation was adopted correctly, and that would give us a very interesting power over people who, over members of management who were not sufficiently supportive of the audit concept. And indeed, I may tell you that in our enforcement actions thus far, since I've been a member of the Commission has been very vigorous in attempting to deal with those corporate officers who have participated in fraudulent financial reporting. We have imposed sanctions or sought sanctions on the chief financial officers of corporations when we find that they are engaging in fraudulent disclosure activities.
I don't know how familiar you are with banking law sanctions, but hasn't it been customary for several years now for bankers who have been convicted of fraudulent activities to be barred from holding similar positions in other financial institutions?
I am not familiar with the banking authority. I don't know if our General Counsel is.
I think they have explicit authority. I believe they may have express authority to do that, but I'm not specifically familiar with it.
It was my impression that that's been customary for some years now. I have no further questions at this time. Thank you, Mr. Chairman.
Sure, thanks, gentlemen. Mr. Reuter, have the self-regulatory organizations established by Congress under SEC oversight been an effective means for setting sound standards and enforcing standards for accounting for members of these organizations? In other words, have they been effective in dealing with accounting problems?
Self-regulatory organizations are primarily in the broker-dealer areas, and we rely upon the self-regulatory organizations to do the inspection function for us for our broker-dealers, and they have been very effective. We supervise them closely, but they have been effective in their audit, in their supervisory function over the broker-dealer community. I'm not sure if that's responsive to your question, but we're confident of their...
Well, you're telling me they have been effective in so far as dealing with the broker-dealers that are under their regulation. But have they been able to deal with accounting fraud or bad accounting over the years?
They have not taken steps directly to engage in supervision of the companies which listed on the exchanges or in the NASDAQ system. They do have a timely disclosure standard, which is different than our standard and has been one which has been quite useful in bringing information to the markets. But essentially, the supervision of the disclosure practices has been with the Commission. We have a very large staff that, as you know, reviews filings and is very vigorous in trying to ferret out financial fraud when we can find it.
How then are we to assume that the SROs are going to do a good job of dealing with accounting problems of persons whose securities are traded on the different exchanges and so forth that are regulated?
Well, if you're going back to the audit committee question, I think that it would be a single question of whether they were going to upgrade their standards. We do not expect them to take responsibility for monitoring disclosures by the companies which are listed with them. We regard that as our...
They might be able to then issue the regulation, but you're telling me that they're going to have trouble monitoring the behavior of the member firms.
No, sir. They collect statistics regarding the compliance by corporations with their rules. The experience with the New York Stock Exchange, as I understand it, was that the compliance with their requirement came over a period of years. It didn't happen exactly in the year when they adopted their new standard, but they began to keep statistics and to report as to how many companies had audit committees. And now, as I understand it, all the companies are, I say I understand it, I don't have perfect knowledge on it, but I understand all the companies in their system have audit committees. So I think we can expect that if an SRO adopted a rule, that they would ensure compliance with their rule.
Well, you have given me nothing to infer that they have either done anything in these areas, nor have you said anything that would encourage me in the view that they have an in-house capability of carrying out the kind of regulatory authority that you have suggested that the SEC wants them to assume under the SEC's policy with regard to the audit committees.
Well, there are a number of matters which the SROs deal with in their listing contracts, and as you know, we are involved with one of them in our one share, one vote proceedings. I'm not here to discuss that, but we have a question of what will be in those listing standards, and I have always assumed, and I have no reason to think otherwise, that they will do anything other than enforce their listing contracts.
Well, if statutory self-regulatory organizations work for member firms on the New York Stock Exchange, why don't we then create a similar organization with mandatory membership for audit firms that want to practice before or in connection with matters that are required by the SEC?
The question of how to deal with the accounting profession has been one which the Commission has considered throughout the years. I think I can say that we are quite satisfied with our interaction with both the AICPA and the FASB, both of which are private organizations. We have, in this particular instance, found that they are responsive. I think that the new auditing standards, numbers 53 through 61, that they've adopted, are the ones you referred to, are a good indication of the accounting profession's willingness to accede to suggestions for change and their ability to behave in a responsible manner.
Now, the body that you have referred to is a voluntary organization. It has no enforcement powers whatsoever, does it?
Neither the well, that's correct in a.
They are totally devoid of any enforcement authority.
Pardon me?
They are totally devoid of any enforcement authority.
They
and
can.
They have about the same regulatory authority that the Board of Governors of a Strawberry Festival would have over its members.
Well, they can. I take it, throw people out of their organizations. That is, the AICPA can. The FASB, as you know, adopts accounting standards, and the Commission is in the position of accepting those accounting standards, so that from the accounting side, the reporting side, we have control over the work product result.
But
with regard
people,
to, excuse me?
People that are kicked out can still keep on practicing, can't they? They're in no way inhibited in carrying out their same earnings functions in the same business that they had engaged in before. Isn't that right?
There are two answers to that. One is that the state regulatory authorities would would engage in examinations if a member were expelled from the AICPA. The second is, as we are suggesting in our peer review proposal, that in order for an accountant's opinion to be acceptable to us, that accountant would either have to be participating in peer review procedures within the AICPA, or would be required to engage in peer review procedures subject to our supervision. So that
you have no rules on that particular point, do you?
at this point,
Yes, sir.
we have a rule proposal, which is
You have no rules at the Commission at this time dealing with those matters.
not at this point. We do have disciplinary powers. We do have a proceeding under our Rule 2E, which permits us to declare that accountant is not fit for practice before the Commission.
Have you ever done that?
Yes.
You have? Would you submit to the committee the instances in which that's been done, please?
Yes, sir.
Now,
We have a number of those. The reason you may not know about them is we have another rule proceeding as to whether or not those proceedings should be public or private. Currently, they're private, and we're examining the question as to whether or not those proceedings should become public.
now, with regard to the state action which you have described to us, can you tell us of any instances in which the states have taken action?
Maybe Mr. Colson can deal with that.
I don't have numbers, but there have been a number of cases where the states have
Did they
taken
do it in
action
the
against
ZBest
accounting firms
case?
or accountants.
Did they do it in the Z-Best case? Was
Not
there
to my
any
knowledge
disciplinary
yet.
action taken there?
Some of the states are quite active, say the state of Florida.
Was there any action taken in the case of Continental Illinois?
I do not know, sir.
Was there any action taken in the case of Penn Central where the most visible and obvious frauds went forward?
There may have been, but I don't know for sure. There certainly was
I'm
in the
aware
case
none.
of...
I was on the committee, and we inquired into it extensively, and the accounting was either so incompetent or it was so dishonestly done that the ICC didn't know about the bankruptcy of Penn Central until 2 weeks before it went under. Now, that cost the federal government about $7.5 billion. Now, bank cases like Continental Illinois are costing the federal government about $13 or $14 billion. There's $1 billion case down in Texas, First Texas. Can you tell me whether any discipline has been taken there with regard to the accountants in that matter?
Which case, sir?
First Texas?
I do not know. There was a case by the state of Florida not too long ago against Alexander Grant in connection with the ESM matter.
That was where there was active fraud. That was in the ESM government securities, was it not?
That was a case against...
active fraud there, though, was there not? And
Yes, sir, that was an active fraud case.
An officer of Grant was involved in active participation in the fraud that cost the government and the states of Maryland and Ohio so much money.
Yes.
But you had no independent audit committee there. And the discipline which has taken place has occurred now about 2 years since ESM went under. As a matter of fact, I'm told that there are other events which have afflicted Grant rather more seriously than the discipline, and rather more early, because they now have lawsuits amounting to about $1 billion against him, I'm told.
That's for sure.
Well, the time of the chair has expired. The chair is going to recognize the gentleman from Oregon.
Thank you, Mr. Chairman. Mr. Reuter, one of the things that I think represents a glaring shortcoming in today's accounting system is that when an auditor finds a major fraud, a material major fraud, that auditor and management has been involved in that major fraud, the auditor is not required to come to you after they have resigned the account and blow the whistle. Now, what we have at present is this incredibly convoluted, bogged down administrative process known as the 8K, where the auditor resigns, the company files a statement with respect to the resignation, and all these steps are put in place. It is not direct notification. We have had testimony before our subcommittee most recently in the ZBest case, where the U.S. attorney told us that had there been a direct notification, or at least he said there should have been a direct notification of the SEC when a major fraud was found. And even the leading accounting firms like Arthur Andersen, I mentioned the article written by Dwayne Kohlberg, are now calling for direct notification to the SEC by an auditor when the auditor finds major fraud and the auditor resigns. I'd like to know why the Commission has not required that the auditor make direct notification in those cases of the SEC.
Sir, we believe that we do not have that power.
If we gave you that power, or let us put it this way, I've introduced legislation in the last Congress to give you that power. Would you support in this Congress legislation that would give you the power to require that an auditor make direct notification when an auditor finds major fraud, resigns, and feels that the public is in danger?
Sir, I would personally, yes. We have not taken this point before the Commission, but I believe that is a very sound step. There are problems in protecting the accountant against possible legal liabilities, but I think those things can be fixed. And I would think it would be something that would be a very useful addition to the Commission's powers if we could have that adopted.
Let me tell you, I'm going to crank out my old bill, and we will work with you on that, because I wish to do by legislation what you have just said, and that is to provide for direct notification by an auditor who resigns on the grounds that there's material fraud. Let me also suggest that I think there's a way we could do this without making it so burdensome. The way it could be done is that when an auditor would resign, the auditor would notify the Commission whether that resignation was routine or not. If the resignation was routine, that would generally end the matter. But if the auditor said it was not routine, they could note that in the resignation, and then your role could be simply to follow up in instances where it was not routine. Is something like that?
That suggestion has been made, and it is one that would I think be helpful in alleviating some of the concerns of the auditing profession, that they would be subject to a liability for having incorrectly what they're worried about. They may incorrectly identify something as fraud which isn't fraud.
Well, and that's why under the proposal that I'm talking about, I think we could deal with the point you're making. The resignation would initially say routine or not routine. If it was not routine, the Commission could come back and ask the auditor who had resigned a series of questions, and then if the auditor was responding to the Commission in that kind of fashion, I'm told that that could deal with some of the liability issues.
We would, if you want to do that, I'd be glad to to offer my general counsel and his staff to help you draft that in a way which would be consistent with the current legislation.
The only other question I had at this time, Mr. Chairman, is one that deals with the civil penalties issue that you raise in your testimony on page 24. You state that with respect to civil penalties, fines, there are many issues that the Commission believes should be examined before specific legislation is proposed. Among these issues are whether civil penalties are appropriate in Rule 2E proceedings. My question, I think, Mr. Reuter, would be why shouldn't civil fines be appropriate in those Rule 2E proceedings?
Well, Rule 2E is a proceeding which deals with the fitness of the accountant to practice before the Commission, and that's the question which is before the Commission, and there's some who think that that's not an appropriate proceeding in which to raise the civil penalty area. If the question with regard to the accountant is whether the accountant is able or does follow GAAP or GAS, his conduct may not rise to the level of violating a securities law provision, and nevertheless the accountant might be unfit for practicing before us. In that case, it may not be appropriate to impose a civil fine on the accountant.
Be happy to, Chair.
I think we've got here a question. Under Section 19, you now have the authority to act where the company files an 8K. Is that right? Where the company files an 8K, the Commission has the authority to ask the auditor if the auditor agrees. Isn't that right?
I would say it's under Section 13, or our general authority to require reports from companies, but
That's right.
we do have that authority.
And you have the authority
to
also to inquire of the auditor at that point, and you have done so, have you not?
Directly?
Directly?
Indirectly, through the management.
Right.
I think that the way we handle that is to require the management to make that report to us as to what the auditor has told management. And that's one of the reasons that our 8K procedure is, I think, correctly characterized as being awkward.
Well, but you can require the company to, do you have to require the company to submit the comments to the auditor, or can you require them to be submitted directly by the auditor?
We do not believe we have the power to have the auditor submit those comments directly to us.
You do not.
And
Now,
that is an area in which
you
I think
do have the authority to deal with the qualifications of auditors, do you not?
yes,
You do.
in the sense that we have authority to decide whether an auditor is qualified to sign an opinion which comes in a filed document.
So there you deal with the qualifications of the auditor.
Yes, whether the auditor is sufficiently independent or
Now,
sufficient.
why would that authority not extend to the powers of the character that Mr. Wyden has been discussing with you?
Well, I can ask my general counsel to opine for you, or if that's not the right word, but to give you the advice he's given to me.
Well, independence is a term that appears in the statute, Mr. Chairman, so the Commission has general authority to define what it means to be independent. There's nothing analogous in the statute today with respect to the situation where an auditor resigns.
Why wouldn't that deal with the problem Mr. Wyden has been discussing with you?
I'm sorry, sir?
Why would that not deal with the problem Mr. Wyden has been discussing with you? Why would that not give you the power to address that problem there?
Because the auditor's independence or lack of independence is a separate question from whether he has an obligation to come forward and disclose some information to the Commission. The latter doesn't relate to whether he's independent from the client or not. It relates to whether he should have some obligation to disclose information to the public or to the Commission. I would say that I believe that if the auditor has previously made or been the source of some sort of a public statement, for example, an audit opinion, and he later learns that that opinion is inaccurate because, for example, of discovering fraud, then he may well have an obligation to come forward with that information. But in the situation where he hasn't yet rendered an opinion or what he learns doesn't relate to a prior opinion, I think it's very difficult to argue.
Why is this power retroactive only, and why is it not concurrent with the events, or at least or prospective?
Because in the situation where the auditor has already made some sort of a statement, presumably the trading markets and securities are relying on the accuracy of that statement. If it turns out not to be true, the investors that are relying on the auditor's assertions should know that so that they'll stop relying. If the auditor has said nothing or has said nothing that turns out to be false, that type of argument isn't available.
You have not satisfied me at all on this point. Chair, thanks, gentlemen.
Could I make one comment, Mr. Chairman? I should point out to you that that our Chief Accountant, Edmund Colson, has written to Mr. Philip Chinook of the AICPA suggesting that it would be appropriate for the AICPA to examine whether their professional standards should be interpreted to require notices to the Commission in certain circumstances. It may be possible to achieve that result by cooperation with the AICPA, and we are pursuing that avenue as a means of achieving the result we'd like to reach.
Thank you. Chair recognizes the gentleman from
Thank you,
Oregon
Mr.
again.
Chairman. One other area I wanted to pursue at this time, Mr. Reuter, is the question of an independent review of the internal controls at a publicly held corporation. The reason I feel so strongly about this is that it was clear, for example, that had there been an independent review requirement so that someone could have reviewed the internal controls at ZBest Corporation, there's no way on earth that ZBest would have passed an independent review of those internal controls. So I think this is a very important area. Now, officials from the AICPA have told the subcommittee staff that the Treadway Commission's recommendations for a management report to the public that gives an opinion on the adequacy of internal controls would improve the present system. They tell us that an independent auditor would be required to take appropriate action if management gives an incorrect opinion. Now, does the SEC take the same opinion on that matter?
We agree with the AICPA.
Okay.
The new SAS 55, which will be in effect on January 1st, 1989, requires the auditor to become familiar with internal controls. And if management writes a letter which assesses those internal controls, the accountant, the auditor, will now have a body of knowledge against which to measure the accuracy and completeness of that management letter.
Now, those same officials told us that the new approach recommended by Treadway would not really result in a complete review of management's opinion unless there's an explicit statement of assurance from the independent auditor that management's assessment of the effectiveness of internal controls is appropriate. They tell us that this would require some additional audit work and that AICPA is presently developing procedures to guide these kind of audit reviews. Now, is that what you're working with AICPA on?
I do not believe that's the case. There have been a whole series of recent SAS standards which put the auditor into finding things out that he didn't used to deal with. For instance, there's SAS 55 deals with control risks, and the auditor must look at the question of whether management is supportive of the control system and things like that, which I think are very positive in putting the auditor now in a much better situation with regard to the internal control system.
Mr. Colson may know something about this additional work. Is AICPA developing procedures to guide these auditor reviews so that we really do get an independent assessment of the internal controls?
Let me say this, though. I think the Treadway Commission recommendation keys in on the SAS 8 responsibilities that exist now. So Treadway recommendation could be implemented without the project the AICPA is working on, in my view. I think what they're working on is some sort of, and we have discussed it with them, some sort of limited review procedures or limited review report that would be available to companies if they were engaged, if the auditors were engaged to give some sort of assurance on management statements on internal controls.
Well,
that project is just beginning, though.
Mr. Colson, I'm not clear then on whether or not the Commission is going to require that there be an independent assessment of the adequacy of internal controls. Is there going to be a Commission requirement to that effect?
The staff thinking and what the Commission agreed to propose would be a management report along the lines of the Treadway Commission recommendation, which would include an assessment by management of the effectiveness of controls. That would tie into the current audit standards, SAS 8, which require the auditor to read other information in a document containing their financial statements and to come to a conclusion whether they agree or disagree with those statements. If not, they're going to have to insist upon change in the disclosure, modify their report, or withdraw, which would kick in the 8K.
So there would be additional work that would be done to obtain the information so that an independent assessment could be done. Is that correct?
No, sir. I think the additional work is what the Chairman mentioned in the form of the new SAS on control risk, which requires a pretty substantive understanding of controls in every audit, regardless of whether the auditor intends to rely on those controls, part of his audit tests.
Well, I hope that you all plan to require a truly independent assessment that would consist of gathering all the information needed to determine if the internal controls are adequate, because I think that's one of the most important of the reforms that we've discussed over the last 4 years, and it seems to me that we've been told that the Treadway Commission recommendation wouldn't result in a complete review of management's opinion unless there's an explicit assurance along the lines I'm talking about.
I think, as I understand the system which is now being proposed, it's that the management letter, which requires an assessment of internal controls, will then set the stage for the accountant who has already now under this new control risk procedure made the analysis that you're talking about. It will require the accountant now to compare what the accountant has learned with what management has said, and that will provide a means by which the accountant will be required either to resign the account or to be satisfied that the management has stated correctly what their control procedures are.
Just so we have it on the record, you will support, and we've been working with the GAO and AICPA on this, and that may be what some of these questions really hinge on, but you will support putting in place a requirement that there be an independent assessment of a publicly held corporation's internal controls.
Well, I cannot state that as a commission position because we have not.
Will you personally support that?
I am supportive of the management letter procedure that I've just described to you. I don't have enough. I haven't considered in detail the question of whether or not we would then whether it would be possible to require a separate opinion on internal controls. I think that's a different matter. What we've set up here is a system whereby the accountant keys off the management letter in disclosing in reviewing what the management has done. I don't mean to say I would oppose it either, only that I'm not in a position to make a judgment.
It is a detailed area, and that should be one we can pursue as well in additional opportunities. One other area, if I might, Mr. Reuter, the Treadway Commission report recommends that all public companies be required by SEC rule to include in their annual report to stockholders a letter signed by the chairman of the audit committee describing the committee's responsibilities and activities during the year. Now, on April 1st, the staff stated that the SEC could require that in a proxy solicitation or information statement, shareholders be provided with annual reports that include a letter signed by the chairman of the audit committee. Now, your statement today said the Commission believes that the proposed audit committee letter would not provide investors with significant additional information and is thus unnecessary. That's the statement today. My question is, Mr. Reuter, are you more likely to review something more closely and pay more attention to it if you're signing your own name to it?
Generally, would I review something more closely if I personally sign my own name to it?
Yeah.
Yes.
How about you, Mr. Gelser?
Yes, I would.
Well, why can't we promote personal accountability at no additional cost by having the chairman of the audit committee sign the proxy statement disclosures?
The question is a narrow one, but we're not sure that we would get much more than a boilerplate kind of disclosure here. We're not sure that the signing of the letter would be the kind of significant event that you're looking at. Really, the answer, the question that needs to be addressed is whether the audit committee is doing its job, and that's a more difficult one.
Well, Mr. Reuter, I think the Treadway Commission's recommendation is a lot more than boilerplate. I think what they had in mind is that the chairman of the audit committee be personally accountable, and they sign the letter.
He already is personally accountable.
Well, I think
don't think there's much question but what the chairman of the audit committee accepts additional responsibility when he becomes a chairman of that committee. The law, at least at the corporate level, is that when you become a chairman of a committee, you undertake certain responsibilities. So that, at least as I understand state law, those responsibilities already exist.
It's certainly possible that nobody amongst the shareholders knows what the chairman of the audit committee has to say unless the chairman of the audit committee is involved, as Treadway calls for, by personally signing. I'm not going to belabor this, Mr. Reuter, but I think that this was a constructive Treadway recommendation. It seems to me a way to send a message to the shareholders, send a message to all concerned that the chairman of the audit committee has been personally involved and has reviewed something in a very careful and a thorough way. And as you and Mr. Gelser and Mr. Reuter said, if you sign something yourselves, you pay particularly close attention. And I think it was that close attention that the Treadway Commission had in mind when it said that the chairman of the audit committee would sign personally the description of the committee's responsibilities and activities during the year.
Just so it's clear what our written response is, pursuant to item 7E of Schedule 14A, companies making a proxy solicitation must state whether the company has an audit committee, and if so, must identify each committee member, state the number of committee meetings held during the last fiscal year, and describe briefly the functions performed by the audit committee. Though that requirement is substantially what you would get if you had an audit committee letter was signed by the chairman of the audit committee. The disclosure is already there. We're talking about form. And at least I guess our feeling was it's already done. That it's not that we're opposed to it, but that it's something that we already have in place.
Well,
it's not that we believe that disclosure is unnecessary.
Well, you state here at page 16, the Commission believes that the proposed audit committee letter would not provide investors with significant additional information and is thus unnecessary. I think if it was unnecessary, the Treadway Commission wouldn't have made a recommendation that it be called for, and I think they felt that it would send a strong message to the shareholders that the head of the Audit Committee, the chairman of the Audit Committee, was personally involved.
Well, would the gentleman yield?
Be happy to yield.
In your statement, you say this. You say that under item 7E in Schedule 14A, companies making a proxy solicitation must state whether the company has an audit committee, and if so, must identify each committee member, state the number of committee meetings held during the last fiscal year, and describe briefly the functions performed by the audit committee. But you don't tell us that what the audit committee has said with regard to matters on the internal functioning of the company must be set forth under that.
Well, describe briefly the functions performed I think that we get a description of what they're
Are they
what they're
required under that language to come forward and to outline fraud that the audit committee has found?
No.
So if they're not, are they required to come forward and set out mismanagement that they have found?
No.
Well, how does that then get into the report? If you've got a company where the officers are active participants in the fraud, as in the case of the ZBAS case.
The financial statements of the company are the company's statements of their own position.
That is true, Mr.
And
Reuter. Now let us analyze that. If the company is diligently engaged in fraud, you don't have the backup of the audit committee to help the commission, the shareholders, the other state and federal regulatory agencies catch wrongdoing in this matter, do you?
Well, yes, if you have an audit committee, you have.
You got the audit committee, but the audit committee's views are not laid before the public, because all this requires them to do is tell what the audit committee does, identify the number of meetings held.
That's all Treadway says.
And describe the functions performed.
Well, that's all Treadway says.
That's the purest kind of boilerplate.
But Treadway says they want you to describe the committee's responsibilities and activities. And we say, we want you to describe briefly the functions performed. If there is a difference,
what Treadway really says is that where the audit committee finds rascality, he wants that identified. That's rather different than the function that you set forth in your requirements under item 17, rather item 7E of Schedule 14A.
Well, sir, if I could read to you, if you'd like, on page 187 of the Treadway report, they have a letter, a draft letter that says nothing in particular. It says the audit committee oversees the company's financial reporting process. The committee recommends the selection of the company's independent public accountant, discussed with the internal auditor, discussed the company's consolidated financial statements, met regularly with the company's internal auditor, and so forth. It doesn't have the kind of detailed disclosure that you're talking about. Simply that's really my reference. What you will get is that kind of letter. You won't get a letter in which the audit committee chairman signs off and says, I think that these disclosures are good.
Can the audit committee, Mr. Chairman, can the audit committee file a letter of this kind if they find that there's fraud or incompetence or mismanagement going on in the company?
I think we have require all of our to sign the 10K? The majority of the directors are required to sign the 10K, and it seemed to me an unusual situation in which the audit committee chairman did not sign the Form 10K, which indeed says to the public that the audit committee, that the financial reports which are contained in the 10K are indeed the company's financial reports and do not contain misrepresentations. We accomplish what you're seeking as a statement by having the majority of the board sign off on the 10K.
Well,
I don't dispute with you the necessity of doing it. It's just a
let's look
procedural.
here. The committee met regularly with the company's internal auditor and independent public accountant without management present to discuss the results of their examinations, their evaluations of the company's internal controls, and the overall quality of the company's financial reporting. Now, that did not happen. You did not have such a certification in the case of ESM. You did not have such a certification in the case of ZBest. You had a situation in the case of ZBest where you had an audit committee composed of two outsiders who apparently not only didn't know what was going on, but never met. The officers of ZBest were actively participating in the fraud in question. In the case of ESM, the same situation is the case. The officers at ESM were actively participating in the fraud. The audit committee didn't and couldn't catch them, or did not exist in the case of ZBest. This requires at least that the audit company, or rather that the audit committee, do set out what their functions were, what they did, and it requires the chairman of the audit committee to essentially certify that they've carried out their responsibilities. Isn't that so?
It tells what they did, yes.
And if so, you have personal liability on the part of the chairman of the audit committee.
I believe you always have that liability because of the function that the liability that the director, the chairman of the audit committee performs in any event. That's not an addition. It's simply a matter of putting it in the annual report. That liability for officers and directors who do not, for directors who do nothing, it exists in the law. And if the directors join in a material misstatement in a reckless manner, I suspect that they are going to be subject to securities law liability directly under our anti-fraud laws.
Thank you. Chair recognizes the gentleman from Oregon.
Thank you, Mr. Chairman. Mr. Chairman, with your permission, I'd like to ask Mr. Reuter a question or two about another matter outside the Treadway. Thank you, Mr. Chairman. Mr. Reuter, I think you're aware that last Thursday this subcommittee discussed with Drexel Burnham, most specifically Mr. Joseph, their practice of allowing high-level Drexel employees to buy substantial amounts of hot issues while public customers were being prorated. My question to you, Mr. Reuter, does this practice, and let us set it apart if we can, so we talk just about the practice of a company allowing its employees to buy these hot issues while customers are being prorated. Does this practice violate SEC rule or regulation?
Well, let me respond first by saying that I cannot discuss any matter that's under investigation, and I do not would not want to have my remarks in any way thought of as having been a comment on any investigation. Nor can I even acknowledge that Drexel Burnham is the subject of investigation. So, with that, if you want to put the question to me in an abstract way, I can deal with it. There is a hot issue and free riding standard, which is an NASD and one of our self-regulatory organizations standards, which deals particularly with the so-called hot issue phenomenon, and it does, I understand, have as a standard that when there is a hot issue, one cannot or should not engage in what's called free riding or withholding.
So there is an NASD rule. What about with respect to the SEC and rules on that practice? And I understand you want to talk about just in terms of the abstract apart from any case.
My general counsel may correct me, but I do not believe we have an explicit rule dealing with that subject. We have traditionally relied upon the NASD to deal with the underwriting function, and that is part of the underwriting, certain of the ground rules dealing with the underwriting function itself. And that's the way we've regulated that area.
Do you think there should be an SEC rule that would restrict employees buying substantial amounts of hot issues while outside customers are being prorated?
Well, essentially, I favor the standard that is within the NASD rule as it currently exists, and I haven't examined the question as to whether or not there should be a separate SEC rule.
Now, on Drexel specifically, could you tell the subcommittee when the Commission began to look into the Drexel matter?
I cannot acknowledge that we have looked into the Drexel matter at all.
Okay. Chairman, I thank you.
Mr. Reuter, just in the abstract, do not the rules of the SEC and the 33 and 34 Act require that the firm which handles the issuance of a hot issue to disclose the fact that substantial amounts of the stock in that hot issue were placed with members of that firm?
We have some rules which require disclosure of underwriter status. If there were significant enough securities placed with, in size, placed with a single person, it may well be that the imputed underwriter doctrine, I think that's the right one I'm thinking of, would apply. And there would be some disclosure obligation, but I don't have in mind myself, it's just that I may not know whether we have any direct rule which would deal with the hot issue phenomenon as you describe it. Mr. Gelser may be able to give you a better answer than I can.
Mr. Chairman, it seems to me that the fact alone that insiders were buying some of the securities or affiliates of the underwriter were buying some of the securities might not require disclosure. However, if those affiliated purchasers were then going to turn around and sell their securities rapidly, you would get into questions as to whether the method of distribution had actually been disclosed unless that fact were disclosed. We also have a rule, Rule 10b-6, which in essence says you can't distribute securities and buy them at the same time. And depending upon the facts, there would be a great likelihood of violating that rule if affiliates of the underwriter were buying the securities, then turning around and selling them themselves to the public while the underwriter began market making in the security. That's a somewhat complex answer, but in the area we're speaking about, Rule 10b-6 would be a major factor.
Would that apply only to stocks, only to investment-grade bonds, or would it apply to also bonds which would be below investment-grade and high-yield bonds?
I believe, Mr. Chairman, that Rule 10b-6 applies to any securities distribution except involving an exempt security, which wouldn't be in question here. The free-riding provision of the NASD that was mentioned earlier excludes non-convertible investment-grade debt, but any debt that didn't fall within that exclusion would be covered by the provision.
How about 10b-5?
Well, Mr. Chairman, again, in the kind of circumstances you're talking about, it seems to me questions might be raised as to whether there was a manipulation going on. I don't think you can say 10b-5 applies or doesn't apply. It's if someone were looking into the situation, they might want to know why the issue was hot.
If the character of the events were of such character that it would lead one to the conclusion that you had a situation of involving market manipulation, then 10b-5 would clearly apply. Is that correct?
Well, that's certainly true. If you say there is manipulation, Rule 10b-5 forbids manipulation.
So the big question would be, of course, to establish whether in fact or not there were market manipulation as on the basis of the facts.
I think it would be better, sir, if the commission didn't take positions in this testimony.
No,
On
Mr.
this.
Chairman, I understand your concerns. I am keenly aware of the Pillsbury rule, and I have no desire to see to it that the Commission is placed in the unfortunate position of having made a comment on any factual situation that is currently before the Commission. I have enough respect for you and also for the Commission to see to it that we deal with that matter in that fashion. And I guess probably the best thing for us to do is to suspend questions on this matter at this particular time.
Mr. Chairman,
Gentleman from Oregon.
would it be permissible to discuss an accounting matter with regard to Drexel at this time?
Gentleman is recognized.
Thank you, Mr. Chairman. Mr. Reuter, the Treadway Commission on page 7 of its report warns that investment advisors and other professionals can be very influential in causing fraudulent financial reporting because of their relationships with senior corporate management. Now, I have a sales brochure of Drexel Burnham Lambert that I would like to ask some questions about because of the Treadway Commission's warning. Now, Drexel, in their brochure, talks about an accounting technique that purports to permit companies to book a profit on underwater mortgages that have a market value that is less than what a company paid for them. Now, the General Accounting Office has advised the subcommittee that this is improper creative accounting that uses technical rules to avoid the real substance of a transaction, which is a violation of a generally accepted auditing standard. My question to you, I think my first one would be, what's an underwater mortgage?
What's an underwater mortgage?
Yeah.
Mr. Colson can answer that so that I don't make a misstatement.
Non-technically, it's a loser.
It's, pardon me?
A loser.
A loser.
Below market value.
Yeah. How is it?
If the gentleman would yield, what you're saying is that it is a mortgage where the security which is offered in support of the mortgage is of less value than the amount of than the face value of the mortgage. Is that right?
That is correct. I'm somewhat familiar with this particular transaction.
Can we just have a moment to... Please. Is this going to be a matter under investigation that we should talk about?
Mr. Chairman, we're very reluctant to discuss anything that might become the subject of an SEC inquiry as to have the effect of precluding us.
To respect that, and again, we don't want to intrude into ongoing inquiries at the Commission.
Mr. Chairman.
The gentleman is recognized. I know the gentleman will proceed with great care in the light of this matter.
Well, I certainly will follow your counsel in this matter. And again, let us just shift to the concept apart from a separate case. And the question I had just conceptually is, how is it possible to book a profit for selling an investment that has a market value that is less than what you paid for it?
Mr. Wyden, I'd really like to urge you, there are case law that has created great problems for agencies where they've been had inquiries at hearings like this about matters and then sought to investigate them later. And I understand your interest in the subject and the hypothetical nature of your questions, and I would nonetheless urge you not to proceed with them.
And we will certainly respect your concern. And I would just ask for the record, Mr. Chairman, consistent with the rules, if there is information that the Commission could give us about some of these concepts apart from cases, I would find that very helpful, because I just looked at this particular brochure, and I just was curious how such a thing was done in terms of a concept, but we will certainly comply with the Commission's concerns and not pursue this further, and perhaps we could learn a little bit more about some of these concepts in a fashion in line with the rules and the Chairman's concern for procedural fairness.
Well, the Chair wants to commend my good friend from Oregon because we are in an area where the committee does not want to intrude into the business of the Commission. Chair would just observe that the Treadway Commission had a couple comments that may be pertinent to our matters here. It says, investment bankers may exploit gaps or ambiguities in accounting standards to devise questionable financing techniques and transactions. Financial analysts, through myopic notions of profitability and other indicators of a company financial health, may pressure top management to focus all their efforts on achieving short-term gains. Through such conduct, legal, financial, and other advisors may become a part of the problem of fraudulent financial reporting. Mr. Chairman, I don't want you and your associates there at the table to respond in any fashion that you don't feel is fully appropriate in the light of all the circumstances. The Chair will simply advise that this is a matter of very special concern to the committee, and this is one of the reasons that we've been in this. You know, I guess maybe if the gentleman would yield the Chair a bit more. I became interested in the subject of overall accounting back in 1972 when we had the collapse of Penn Central. The Secretary of Transportation, Mr. Volpe, was going to be in here for a half hour. And he was going to tell the committee that if we didn't give $250 million in loan guarantees to Penn Central, that railroad was going to go under and it was going to result in the collapse of the entire economy of the northeast quarter of the United States. The committee had a huge battle, which some of us here in the room still remember. And the result was Mr. Volpe came back for at least a second day. The committee had a big investigation by the ICC. And in that, a number of facts came out. First of all, the accounting was so bad and the reporting was so bad that neither your agency nor any of the investors in the securities of that unfortunate corporation had the vaguest idea of what was going on. The ICC didn't know that the bankruptcy was going to occur until 2 weeks before the event actually transpired. One of the interesting things was that the management of the corporation were setting up investment clubs to take advantage, and I think this is almost a direct quote, of the unique advantages of the expenditures of Penn Central. The company saw a situation where, first of all, the Financial Committee and the Executive Committee had disposed of all their stock holdings by February of the year. The directors and other officers were out by March. In April, the committee heard this catastrophic predictions coming in. The ICC didn't have any idea there was any trouble in the horizon. And about the 7th of May, the company went under. The federal government wound up with a liability of about $7 billion on this matter. We got about $2 billion of it back when we finally sold the corporation. But I became aware of the fact that accounting could lead this country into situations which were appalling. More recently, we've had a wave of banks that have been going under. Savings and loans have been going under. Government securities dealers who have been engaged in some real rascality. In some instances, the accountants couldn't catch it, didn't dare report it, and in some instances, they were actively participating in the events in question. We wind up with a situation where investors are defrauded. The government winds up with huge liabilities. In one instance, in the case of one bank, it's reputed to have been only $4 billion, and in point of fact, it was about 14. In the instance of another bank more recently, it's about $1.5 billion or $1.75 billion. The entire savings and loan industry in Maryland and Ohio were brought to their knees by one set of rascals and one unfortunate set of circumstances. And we see no end to the kind of wrongdoing that's sheltered by inadequate, or in some instances, as we saw in the case of ESM, corrupt accountants. And the question is, how is the regulatory system going to work? How is it going to prevent active wrongdoing which enriches rascals at the expense of honest men, which shakes the confidence of the American people in the accounting system? Way back when I was a very small boy, my dad was one of those who helped write the 33 and the 34 Acts. A lot of people have forgotten what happened then, how destitute and unfortunate the country was. They've forgotten that this nation had all of its banks closed. Confidence in the financial system and banking system was at such a low ebb, nobody would put their money in a bank. They'd much rather stash it in a mattress than to put it in the hands of a banker. There were 3 million communists in the country, and Roosevelt worried, in fact his paramount worry was that there would be some kind of a communist putsch which would take over here. That was one of his principal concerns. One of the main reasons this went on was because everybody had lost confidence in the financial system. And it became absolutely imperative that something be done to restore this confidence. That confidence worked pretty well for a lot of years, but of late it's begun to be shaken. The events of October 19 caused major problems last year. And other events have led this country to a period of great concern. This committee is troubled about the input that we have with regard to accounting so that honest men can know what is going on. To see to it that the reports that are required by your agency under the 33 and 34 Acts are properly done, factual in character, truthful, don't mislead. We have a lot of related problems: insider trading, market manipulation, wrongdoing in the financial marketplaces of the nations. Hundreds of banks now that are troubled, and that's a word of art. A lot of savings and loans that are on the brink of going under. The regulatory agency that's supposed to retrieve these savings and loans is now charged with wrongdoing, insider trading, preference for themselves and for their special friends on the part of the officers. And somebody's got to do something to see to it that we have confidence in our system again. Not just that we go by the simple letter of the rules, not just that we say, well, that would be a burden on the commission or a lot of reporting, or it would be a burden on honest men. Of course it will be. One of the reasons that the commission's drawing pay is to do that. One of the reasons that we put a burden on honest men is because that's the only way we can catch the rascals or the knaves. And I just think, Mr. Chairman, that it is important to you, and it's important to the country, it's important to the commission, it's important to the confidence of the people out there, that the commission do a vigorous job of seeing to it that good accounting is used to the fullest that we can to assure that public confidence is restored and maintained, that rascals don't prosper, that honest men can feel safe going in the marketplace. One of the things I observe with enormous distress is that the little guy's now out of the marketplace. And the little guy now probably feels no real reason to think that he has some kind of a shareholder interest in this country and its institutions, because he's just scared to death. So he goes, puts his money in a bank or a savings and loan, and there he only does it because he figures that the United States is behind it by reason of the guarantee that the federal government gives. So I think it's very important, Mr. Chairman, that your agency look at this not just as something where you were presiding over some kind of set of ritual rules to be applied the way the old common law judges used to, or to be applied the way the religious courts used to, but that you have a very real responsibility to participate in the protection of this country and its interests, and to see to it that what has to be done to assure that public confidence is maintained. Not so much the catching of rascals. We're always going to be catching rascals. We won't hang enough of them, but we should. But to see to it that the basic public confidence remains, whether it's bonds, stocks, high yield, low yield, whether and remember, the reason that they set your agency up the way they did was they couldn't figure out how they could regulate a securities market. The only thing they knew was that if they made people tell the truth, they let the sun shine in, that honest men would prosper, people could have confidence, and that rogues wouldn't find shadows in which to hide. I think those are very important considerations, and I think it's a very dangerous time, and I'm troubled about the possibility of something getting loose because we don't watch it as vigorously as we should. And I do want you to understand, Mr. Chairman, I have great respect for you and for the institution of which you're a part. But I hope you'll make it work, and I hope you'll see to it that the accounting component, which is really the device which enables you to know what's going on, in fact work, and work well in the public interest. If they don't, we will probably see more misfortune and probably ultimately a total loss of public confidence in the securities industry that you're supposed to be looking after down at the Commission.
If I may respond.
Sure.
The Securities and Exchange Commission has had a long tradition of effective enforcement of the disclosure laws, and that tradition has included vigorous attention to accounting and financial disclosures. And I found when I came to the Commission as chairman a staff which was extremely dedicated to this proposition, and I'm pleased to tell you that what I have found is a staff which is doing as much as they are able to promote full and effective disclosure. That's true both in terms of the review of filed documents, the setting of accounting standards in cooperation with the private profession, and the enforcement of financial fraud. And I will certainly give you my assurances that while I am chairman, this tradition of effective enforcement of the securities law will proceed with the utmost vigor. And I think there's one other point which needs to be emphasized in a hearing which deals with fraudulent financial reporting, and that is that the accounting profession in the United States is doing a fine job in attempting to meet the standards of full and effective disclosure. I think the profession, both in the auditing and the standard setting and in the accounting standard setting area, is proceeding in a way which is really the model worldwide for effectiveness. That does not mean that there are not and will not be some people with crime in their hearts who will take steps to evade the laws. And all I can say is that I think that the accountants generally are as equally in back of improving the system so we can find the wrongdoers, because the profession, as well as and agrees, I think, with the Commission and with you, that the task is a very important one.
Mr. Chairman, that's true, but the accounting profession has major problems. There are a lot of good and honorable men in that body. And they're trying, and they went out and they set up the Treadway Commission to find out what it is that profession should do with regard to being more effective in terms of serving the public interest by having full and fair and proper disclosure. They've got major problems. If they disclose facts, they are subject to lawsuits, to libel, to defamation, Whether they win or lose, they've got a major problem there. If they don't, they've got a different problem. If they have no basis on which they can come forward by reason of a report or some requirement that they do something from your agency, they may be compelled to suffer in silence because there's no way they can avoid the possibility of serious litigation against them for having done what they think is right and proper. And if you'll read the very fine work that was done by the Treadway Commission, you'll find out that what they're trying to do is to enable themselves to become more competent, to serve the public interest, and to do so without all of the rather awful peril that they confront from disclosing. And in a number of instances, if they're not required to report things by the SEC, they act in disclosing wrongdoing at great personal peril to themselves, their corporation, or the company of which they're a part. And the same is true with regard to auditors who conceive, the internal auditors or the audit committees who face a similar problem. And so what they're really seeking from you and from the SEC, and what this committee is really seeking, is that you see to it that everything is done to facilitate the honest action of honest men, not to worry about the number of phone calls you're going to get down there at the commission or the amount of additional work you're going to get at the commission. That's part of the burden that you, Mr. Chairman, and the commission take when you hold up your hand and take oath of office to serve in that distinguished responsibility. And a lot of times the simple fact that wrongdoers and knaves are going to be knowing that this kind of disclosure is going to be required is going to be a massive deterrent to them in engaging in that kind of activity. But I'm not sure that you or I can sit here comfortably and say, well, the accountants aren't doing what they should do and they ought to do this, unless you can afford them some measure of protection and shelter in connection with doing what it is they should do and what I think most of the honest and honorable men in that particular institution want to do. That's the reason this committee takes so very seriously the very fine work that was done by the Treadway Commission. That's why this committee intends to do everything we can to see to it that the efforts of the people who put that together, and it's a fine document, are properly supported. Because I think that without that, we're going to be seeing more ESMs, more Continental Illinois, more ZZZZ best corporations, and more rascality of every manner and kind. Because we simply don't support honest men in a fashion which makes them comfortable in doing what they want to do. Very important, Mr. Chairman. Gentleman from Oregon?
Yeah, just very briefly, Mr. Chairman. First of all, I want to associate myself with your remarks and think that they address all the key issues. Mr. Reuter, I was really pleased to hear of your personal support for legislative authority being granted to the Commission to require direct notification when an auditor resigns on the grounds of material fraud. I think that's exceptionally important, and I want to tell you I'll be on the phone to your staff trying to follow up on that, because I think that's key. And at some point, after management has been notified and you go through these various procedures, I think we absolutely have to have a process for an auditor to be able to inform the Securities and Exchange Commission of major frauds. And I want to commend you for taking that position today. I also think we made some headway with respect to requiring the Independent Audit Committee by rule. I know of your personal position on it. I know there will be a difference of opinion within the Commission, but I'd like to think we made some headway there as well. So I appreciate the chance to discuss these matters with you. Look forward to following up, and thank you, Mr. Chairman.
Mr. Reuter, Mr. Gelser, Mr. Colson, the committee thanks you for your assistance to us this morning. The committee will stand adjourned until the call of the chair.